be recording now. Okay, this is LAWS 12059, Conveyancing. This is topic 3, dealing with seller disclosure before contract, with a specific focus on the houses and land form of contract. You'll be aware, hopefully, even at this stage, that there in Queensland there are in fact 3 standard form contracts. That's not the case necessarily in other jurisdictions, but in Queensland there are 3 standard form contracts. That's for houses and land, which is basically residential sales. There is the commercial contract, and then there is the, basically the one dealing with community title under the BCCM Act. All right. Now, the other thing right. Thanks, Grant. Thanks for that. I'll get onto that and fix that so people can see that Zoom for landlord. The other point I want to bring out with regard to this topic and the next topic is that I have loaded onto the Moodle website, and I have, in the presentation I've recorded for this topic today, I've made strategic reference to the document that relates to this topic, and that is I'm referring to the Property Law Review project and the 2 discussion papers which have emerged from that project. I've put both of those onto the course website. The first discussion paper, which specifically relates to seller disclosure, I've put it on under topic 3, and it's a PDF doc, and you can open that up and have a look at that. And then the next one, with regard to the BCCM Act and lots, I have loaded that up on topic 4. Now, there's also reference in the first discussion paper to BCCM Act basis for seller disclosure requirements. We go into that a bit more in the next topic. So the first discussion paper straddles across both of these topics. But the point I want to make is that this might sound a bit unusual in the area of property and land and conveyancing. One tends to think of these areas as being a bit more static than other areas of law like tax and corporations law and so on and so forth. These are normally tried and true in a sense. But we are in a very dynamic space in Queensland at the moment, especially in conveyancing. We're in that dynamic space because we've got this property review project underway that is actually looking at some of the strategic state-based legislation that impacts upon land contracts and the conveyancing process, firstly. And secondly, we have the emergence, or the unfolding, if you've a better way to put it, of e-conveyancing and the e-conveyancing project or strategy. Now, I referred to that in the first topic in the notes and gave you some further resourcing on that through the Moodle website, PEXA and so on. When I was at the Property Law Teachers Conference for 2.5 days at the end of last week, when I arrived up in sunny Brisbane, it was very sunny when I arrived, it was very nice, not cold like it is down here, down south. I had also arranged a meeting with people at the Queensland Land Titles Registry. And I'll say more about that in land law as well, but and I've also loaded up, by the way, a document onto the land law course website that you can have a look at, a presentation developed by the Queensland Land Registry people. But the point that I wanted to make was that, that I had a couple of hours with people there, which was really interesting, and I'm going to try and implement some of what came out of that meeting into both of these courses, conveyancing and land law. But one of the things that just emerged in terms of e-conveyancing, which is directly relevant to what we're doing here, is that this is a staged project, so that it's staged in the sense that it's not being all rolled out at one time. It probably, even if they wanted to, they couldn't do that because of the impact and the nature of things. It's certainly not being rolled out in a uniform way across Australia, so that it's underpinned. I mean, it's a national strategy, but underpinned by state legislation or territory legislation around the jurisdictions, so that we have, legislation here, 2013 legislation here in Queensland. And interesting to hear from the people at Queensland Title Registry's office to say that the point they're up to at the moment with regard to e-conveyancing is what you can currently do is you can, through the e-conveyancing process, you can record a mortgage, or you can record the release of a mortgage. That's it. Nothing more at the minute. no contract of sale, etc. And so it is a staged project. But please keep a watching brief over it, because it's emergent, and that's another thing that's impacting upon what we're doing. And I really want to really emphasise quite strongly with you the significance of electronic conveyancing in this area. It's going to literally transform this field of law, if it's not going to transform really the way you function as a lawyer in the future. We've been having some discussions in the school about that. We had a meeting, colleagues, just this week, and had some discussion about Stephen at the moment is over in the US doing some interesting stuff with some law schools there. But it's going to have an impact in a whole lot of ways. And in property, where it's going to have the greatest impact is in the conveyancing transaction and the conveyancing process. That's one. Two, which is already in place, and that is the computerisation of land titles. Now, of course, that is also relevant in land law, but in this course, of course, we're not only concerned with the contract of sale, but we're often also concerned with associated documents that are part of the contract of sale. So maybe a title search, most typically of the lot, which is the nomenclature in Queensland. In other places, we refer to a parcel of land, but in Queensland, we refer to a lot. So we have these searches of title in electronic form. The other interesting thing, again, this is a bit for land law, but relevant here also, that the way that we refer to these documents of title, the people in the registry refer to them as either as an indefeasible title or as a current title. They have stopped referring to it as a certificate of title. And that's quite interesting, because you'll be starting to discover in land law that phrase certificate of title is pretty significant, and the certificate of title itself, and who has it and who doesn't have it, and who's controlled it and who doesn't control it, and what they've done with it and what they haven't done with it, becomes pretty important in terms of examining people's behaviour and conduct at the end of the day. So more of that in land law, but just emphasise electronic conveyancing, the potential impact, and you need to keep thinking and turning your mind over on that, and don't think that I won't find ways to test your appreciation and understanding of that, because I will, but it's something that you really need to take seriously in a big way, because it's going to be the future. That's, if you go into practice, that's what is going to be the way things will happen. And then how that's linked also to just electronic titling, which is already here. And okay. And the other thing, of course, in Queensland, we actually only have Torrens title lots. We don't have general law land, as is in other jurisdictions. Sometimes we can create hypotheticals to allow people to think about general law issues, but in reality, we don't have that. All right. So let's. Can we launch with those few opening remarks into the tutorial problem questions? Let me just say, maybe you've already seen this, that I've seen both of your responses to the problems for this topic, Very nice responses from both of you. I've given a little bit of feedback on the Moodle website. You may or may not have seen that at this point. Just a word of warning before we start our discussion, and the word of warning is that very important to remember that in this area of land contracts or conveyancing, we can alternate between those. We call the course is called conveyancing. I'm trying to decide which one was best, but anyway, that's what we decided. But it's really important to remember that we've basically got three areas of law, three sources of legal rights and obligations, if you like. We've got the contract of sale, we've got the terms within the contract of sale, both the standard terms that are on the printed form, and as we will see in due course, any other terms that may have been added in the nature of what are usually referred to as special conditions. Second, we have the specific legislation that impacts in relation to transaction and in relation to the particular lot that we're thinking about. And we'll see actually tonight in today's this topic some of that array of legislation that can affect, and it's not just in quotes property or conveyancing type legislation. It's a wide range of legislation that impacts on what can be done and what can't be done with lots of land for other reasons and other purposes. We'll get into that. And then third is, as ever, the body of general law, case law. So when you're responding to these tutorial problems, be mindful of those if I can put it like this, the trifecta of legal control and regulation on the conveyancing transaction. But with regard to the third, that is general law or case law, there needs to be a proviso of caution. And why should I say that, right? Well, one has to be cautious with judicial decision making at the best of times. However, in this area, the proviso of caution is for this reason. Because of the differences between the different jurisdictions, both in terms of legality and practice, we need to be cautious in the application of case law outside of Queensland to resolving problems and issues and disputes that arise in Queensland. That doesn't mean that the case law, New South Wales, Victorian decisions and whatever is irrelevant, not at all. But one needs to be mindful of the nuance of difference, okay? And this will come up also in when we, in land law classes. Very interesting, the conference that I was at, this was a conference with delegates from all the various jurisdictions of Australia, mostly. No one from, I don't think there's anyone from the territories, but all the states were there, property scholars, teachers and whatever. Also represented people, colleagues from Singapore, Malaysia, unfortunately, sadly, and Hong Kong and New Zealand. And one of the points that came across, and I've already given you some of this, material, not from those Asian jurisdictions, but from other, other cognate jurisdictions, including New Zealand on the land law, for instance. One of the things that really came strongly across was the fact of the total lack of unanimity across the jurisdictions with regard to property law, and that it continues to be an area that is very much subject to state-based regulation and control from a legislative point of view. But there is a body of case law, of course, that emerges through the jurisprudence that has broad application, but we need to be careful where we're dealing with matters and procedures and practice that is very jurisdictionally based or oriented, drawing on what's going on in other jurisdictions or relevant case law and so on. I mean, High Court decisions, of course, guiding principles, yes, no issue, except that, again, look at where it's coming from and is there nuances of difference between the legislative provisions and so on and so forth. All right, so with those opening and supplementary remarks, I'll open it up. Problem 5. We'd like to have a stab at that. You're both muted. Why is that? I should add, I've had the benefit of reading your submissions. I've had the benefit of reading your submissions in advance, so I'd be happy for you to speak to those submissions.
Yes, but I haven't read your comments.
Sorry again? What did you say, Lisa? I didn't hear you.
I haven't seen your comments, so I don't know whether it's right or wrong.
No problem with not seeing my comments. You can just start us off, okay? And then Grant will chime in, I've got no doubt. So just start us off. What's going on here? I mean, what I want you to do is don't just read your answer, obviously. Why have I given you this question? You know, what is this? What is important about the thing that I'm tossing up in this question?
A disclosure statement was failed to be provided.
Yes.
On, I guess, a broad aspect,
yeah.
I was sort of looking at the question more as, I don't know whether this was the case, but I thought you were trying to get me to think about the strict black letter of the law versus the practical realities of what happens in practice, and how the court is considering I guess, the procedural aspects of how that works in reality, so that they're not sort of impeding property transactions and putting obstacles in the way.
Surely I wouldn't be getting you to think about those dimensions.
Well, then, on one track, man.
That's precisely exactly right. And that's what I need you to always be doing, by the way. All right, I need you to be always exploring and looking into what's going on. Okay, and that idea of and then particularly in this course in conveyancing, to try and see the link between the legality, Grant's used the phrase black letter, yeah, we can use that phrase, but the legality of what's happening on the one hand, with practice on the other. I mean, what are the practice imperatives in conveyancing? Conveyancing is a very practical, at the end of the day, it's a very practical, a very applied science, if I can put it even, in that way. Because it's actually, the transaction process from go to woe, in a sense, from entry of the contract, or even pre-entry, and we're dealing with matters here pre-contract, to entering into the contract, the steps and stages of the contract, and then the completion of the contract, and all that happens in between. So it's a process, and it's significant for people or for entities. Doesn't matter whether we're talking about a natural person or a corporate person. It's significant because it's about transferring interests in land. Right? Now, at the same time, you guys and others, most, all of the people in this course, studying land law at the same time. So you're trying to get this around your head at the same time you're doing this. But so it's very applied and very practical, but it's underpinned by a legal framework. Okay, and that legal framework comes from various sources. So yes, that's quite exactly right, Grant. The other thing is that I'm trying to get you to see the relationship between certainly a significant piece of governing legislation in this area, the Land Sales Act, and how that is working, how that's been interpreted by the courts, and again, going back to that point that I raised earlier about being careful about judge-made law. Of course, in this case, we've got a Queensland decision interpreting a critical piece of Queensland legislation. No problem, okay? We're in the heartland. Okay, no problem. But it's when we start, seeing that we might be referring to New South Wales decisions or Victorian decisions, we then have to exercise caution. Right? So that's the first point that Grant's teased out for us in terms of the relationship or the disconnect, if we can put it like that, between practice on the one hand and legality as grounded in the law, legislation, case law on the other. Yeah. What about the actual thing here that's at issue? Is there anything about that warrants a sort of a more reflective approach or thinking? What am I getting at?
Are you talking about the transfer documents?
I am talking about the transfer documents, ma'am. How is it specifically referred to?
Because the seller argued that they were available.
No. What I'm after is, how is the document specifically referred to? What is it called? Well, I mean, how is it described? Basically, that's the best way to put it.
An instrument of transfer as an instrument.
Yes. Go a bit back. The character of the instrument.
A registrable.
That's the word. That's the magic word. The magic word. Magic. There's lots of magic happening in property law. And this idea of registrable. Okay, now in this course in conveyancing, we're sort of responding to that and asking, well, in the context of a conveyancing transaction, what does that mean? And is that a document or an instrument, a property instrument or land instrument, of a kind that satisfies the requirements here in terms of the seller disclosure issues. Right? Now, unfortunately, we haven't yet had that discussion in land law about this descriptor, registrable. But basically, if I had a whiteboard here, and I've been trying to turn my head around as to how I can have a whiteboard on a Zoom session, I'll probably find a way, but I haven't yet. If I had a whiteboard, I would actually construct, maybe I can do it like this, construct a pyramid or a triangle that's upside down. And I would put in the center of that, if you've got a sheet of paper in front of you and a pen, do that. Take a pyramid or a triangle and upside down, okay? And inside the upside down pyramid, I want you to write the word instrument. And I then want you to, on the corners of the triangle or the pyramid, there's 3 words that we're going to put. One, not at the bottom, don't put it at the bottom, but at one of the top 2 corners, you can write the word registrable. Right? You can even circle it, make it more interesting, and then we can upload it to Moodle and we can share it all with each other if you want to do a nice job on it. That'd be great. I'm happy for any assistance, by the way, in that regard. I struggle with graphics, but I have a great editor that helps along the way. And we'll talk more about that in land law with some of those diagrams that I've been having some fun with, and I hope they're useful for people in terms of unpacking complex case scenarios. But so we've got registrable, okay? What do you think might be the other word that we might like to put on the other corner of the upside down triangle?
written?
That's a good attempt. It's not the one I want, but it's a good attempt. The word I want you to write there is unregistered. So we've got registrable, and then we've got unregistered. What do you think might be the word at the bottom of the pyramid? Starts with an R. Take away the UN, and what do you get? Not the capital UN. I don't mean that. Take away the UN in front of registered, and what do you get then?
Registered.
Exactly. So this is really critical, but this is not really, unfortunately, a debate that we have in conveyancing. This is an important critical discussion that we have in land law, and that is that instruments, land and property instruments, land law instruments really, we can talk about things being unregistered or not able to be registered. We can talk about registrable instruments, and we can talk about registered instruments. Okay. In this context of the Fazigi case, of course, the transfer, and that is a critical document within land law and within a land transaction. It's the recording of the transfer that actually transfers the interest in Torrens title land from the current owner to the subsequent owner, from the seller to the buyer. It's not the contract of sale. It doesn't do that. It's the lodgement of the property law instrument with Queensland land titles or land titles registry. And here's another little point. And I'm sorry I've got to slip across to land law a little bit, but here's another point. And this is interesting. And I was fascinated by this. And many years ago, and you've seen in my notes already, I've referred to a thesis that I wrote back in the mid-1980s on the Torrens system. But in Queensland, no one lodges an original property law instrument. No one. In fact, the registry itself doesn't even retain original documents. If it gets hold of them, it destroys them. I was horrified at the thought of destruction of original property law documents. What they do is the original transfer, or the downloaded form, if you put it like that, because they haven't got to a stage yet where they accept digital signatures. This is the process of evolution of e-titling and e-conveyancing and e-technology in this area. So the form of transfer will be available from the website. You'll download it, print it off, fill all the bits and pieces in. The signatures, critical, absolutely critical, and we'll see how that emerges in both of these courses in due course. And then they scan it in, and they send a scanned-in version to the Land Titles Registry. And the Land Titles Registry has special technology with optical identification capacity to carefully read this scanned-in version of the original document. And that's what they use as the basis for recording the transfer of interest in the land. Now, in this problem question, in the Fazigi case, which both of you have already mentioned and referred to in your responses, the transfer document was with one of the parties for a particular purpose. What was that?
It was stamping purposes only.
Mm.
It was,
what does that mean, Lisa? What's this stamping business? What does that mean? Everyone's jumping around, stamping their feet, aren't they?
Yeah, I'm not exactly sure what the stamping purposes only was, but it means that they couldn't register the transfer.
Yeah, because it was, who was it? Who held it? Which party held it?
The buyer.
Because of course it's the buyer or the buyer's representative, solicitor, who will have it, who will lodge it once the interest has been, the contract has run its course and it is completed, and then you will lodge the transfer, which will transfer the interest. This is the link between the property law instrument and the contract of sale. Right? So the contract governs the process right up to completion, as we'll see a bit later in this course. And then the transfer, which is the critical document, is then lodged for registration. But in Queensland, a scanned-in version is what ends up in the registry, the land titles registry. But this idea of stamping, Grant, any ideas on what stamping means?
Certification, or is that the point at which it becomes registered?
I have to say no, but the certification is possibly relevant. Look, I'll just be plain about it. The idea of stamping is, historically, you took the contract of sale to the relevant Department of State Revenue, and it was stamped with an official stamp by State Revenue because you pay revenue on the transaction. It used to be called stamp duty. In some states, some places still call stamp duty. In Queensland, there is now the Duties Act, right? Not called the Stamp Duties Act anymore, the Duties Act, and you pay state revenue duty tax on the transaction. If you've ever purchased a property, then you'll realise that it's not insubstantial, okay? And it's paid by the purchaser as a percentage on the sale price, basically. And that's not uniform, across the states and territories, but because it's linked to the actual purchase price, then it's another matter that the purchaser must consider. But the purpose, getting back to your issue about certification, Grant. So the stamping process performs the task of revenue raising for the state of Queensland in this case, on the great multitude of contracts of sale that take place. Statistics are unbelievable, really, in terms of the volume. Anyway, but the other matter is, and you may have learned about this in your evidence studies, if you pursued your evidence studies at this time, is that documents have to be official to be able to be entered into court proceedings. And something like a contract of sale must be stamped before it can be tendered as evidence in a legal proceeding. So it has that legal role or procedural role, as well as revenue raising role. But the point in this case was that the buyer's solicitor had it for that purpose only, not for the purpose of sending it off to land titles and then allowing the full interest to be transferred at that point. Because what often happens is the document gets sent at an early stage in the process so that it's all ready to rock and roll at the relevant time and there's no issues. But it's sent with the understanding that it's sent only for that purpose, not as a finalisation of the process. And that's what's going on in the Begley and Vasicci case. That helps us to understand what's meant by a registrable instrument transfer, in the sense that the fact of it being with the buyer's solicitor for that purpose didn't mean that it was a registrable instrument. That is, everything was done that needed to be done for this transfer to be registered with the Land Titles Registry. No, it wasn't. And that comes back to that critical idea about what registrable means, because under the Torrens system, the interest that you have is statutory under the Land Title Act. But if you've done everything that you need to do, and all that you haven't done is register your interest, so the document, transfer, or whatever, everything is right, it's registrable, ready to go, but hasn't, then the general law will say that you have a legal interest. Now, when we get to issues about priorities in Torrens title, and we have unregistered interests, and this is a discussion to be had at that time in that course, but we then need to examine the nature of the interest to see whether we can further classify those unregistered interests as legal or equitable. And then we get a competition between differently described interests that aren't registered. Okay, so this idea of registrability, or the document or the instrument being in a registrable state as opposed to not in a registrable state, is actually quite critical in terms of characterising the nature of the interest potentially that that party has at that time. The other point about this question too is, and I think Lisa, you pointed this out in your response, is that in terms of the relationship between the Land Sale Act and other processes at play, then you have to see the significance of that legislation in the process. And because this is a critical piece of legislation in this area, and so we need to be mindful of that. And as far as the Land Sale Act is concerned under Section 9.5, we need to have a registrable instrument of transfer, and we didn't have that on the facts of Begelian Physician. Any questions before we proceed on to the next problem?
Not from me.
Okay, all right, good. Let's go on to problem 6, please. Who'd like to have a go at kicking off problem 6?
I'm just quickly reading the question to refresh my memory.
Oh, sir, how can you say such a thing after the answer you provided on the Moodle?
Because that was a cut and paste from something I did a little while ago.
Ah, there we go. There we go. What is Section 21 about?
The seller providing a written disclosure statement about the property.
Just can you a bit louder, Lisa? Sorry.
Oh, sorry. The seller providing to the purchaser a written disclosure statement.
And what sort of things do we find on that written disclosure statement?
The property dimensions, the physical location, the floor or level, because you're talking about a strata development. So it's basically so you can identify that specific lot that is yet to be built. It's so that you can sort of, I guess, physically identify where it is, the dimensions, the size of it, etc.
Yep. And notice that this is in relation to proposed lots, okay? That's the point that you brought out then, Grant, about yet to be built. Very important, okay? Proposed lots, okay? Just on that point, I'll just refer you back to the distinction between under the Land Sale Act 1984, proposed lots and proposed allotments. Okay, it's an important distinction teased out in the notes, but also in your textbook, chapter 3, at page 91. Right, and I'll just read you, there's a couple of lines there from the bottom of page 91 under 3.3.3 Land Sales Act 1984. A proposed allotment is a single parcel of land other than a lot, that's other than a lot, as defined in the Act, that's the LSA, as delineated on a plan of survey to be registered either under the Land Act or the Land Title Act. In other words, the proposed allotment is vacant, unregistered land. So a proposed allotment is vacant, unregistered land. A lot, on the other hand, as defined, includes a registered lot and a lot that will become a registered lot upon registration of a building units plan, a group titles plan, a leasehold building units plan, or upon registration of a plan and recording of a community management statement under the BCCM Act. Okay, so we're looking at proposed lots here, right? And so it's not vacant, unregistered land, but it is a lot that is proposed to deal with the matters that I've just referred to there. So very important to understand, you know, the types of what in other places we tend to refer to as parcels of land, but in Queensland we talk about lots, what we're actually getting at. So these details, critical details, are identifying this lot yet to be registered. Okay, so you can imagine what sort of details would we be talking about, do you think? Hello, are you back? You still there?
Yes, it was just Mark. Oh, there you are.
Yes, what happened?
Yeah. We could still see each other. It's just you.
That was most bizarre, and I'm still recording, and it just went off and it came back on again. I never know that before. Thank goodness for that. So what sort of details?
Sorry, details for what? Because I couldn't hear what you're...
Under this certificate, right, under the Land Sales Act, Section 21, describing, you know, the lot, proposed lot, what sort of details? What sort of description, what sort of information would it have?
Anything that specifically identifies that property.
Give me an example.
Easements?
Could be. Yeah. Grant, any ideas?
The physical dimensions, the location and or references on a building plan.
Yes, yes. All of these things that specifically describe this proposed lot, right? Could the time between when that statement is issued under Section 21 and the time when, or a later stage in the transaction, could any of that information or details change?
Almost certainly.
Almost certainly. That's well put, sir. Well put. Almost.
One thing.
Go on. Yep.
It's one thing to have a theoretical plan on paper. It's another thing to put it into practice. So during construction, council building regulations, inspectors, you name it, there are going to be changes and modifications that take place.
Exactly. So, and don't forget, again, we're discussing this in the context of seller disclosure requirements pre-contract. Okay? So with a proposed lot, the seller is selling that to a buyer, right, in terms of something that is still, you know, being created, if you like, for the purposes of becoming a registered lot under Torrens title, under the Land Title Act, assumedly. So things can change. Descriptions can change. You know, aspects of how this is best described can change, be affected by various things, as Grant's mentioned. So the obligation under the LSA in this context is then explained through Section 22. What does Section 22 tell us?
I just stopped talking because I thought you were.
I've just stopped talking too. So I'm asking, what does Section 22 achieve? What does it do?
That's an amendment that has to be put in if there's any changes, but it's only triggered if there's something wrong with Section 21. Yeah.
So Section 22 is basically it's referred to as a rectification statement to basically make the description details and identification details as accurate as they can be. And you can imagine that this is important for the buyer because they've got to make sure that this proposed lot is exactly what they think they're buying in terms of how it's described and how it's identified. But important to remember, and I note this back on page 16 of the notes, that Section 22 rectification statement only relates to a Section 21 statement inaccuracy. That's all it relates to, okay? So that's what sets off or triggers the need to issue a Section 22 rectification, but only that, not other problems, other issues. And so, which, there might be other purposes or rationales for and other ways of attending to those matters, okay? So this question is really getting you to think about the importance of identification details to clearly know what it is that's being acquired, the interest over this lot of land, in a situation where that is still being finalised, if you like. So it's a proposed lot, not a finalised lot. People are, entering into conveyances or transactions for all manner of lots of land in all different situations. Do not assume that it's just where we have an existing land with some existing structures on it and they're purchasing it. That is there's a lot of those happen, of course, but there's a lot of property development that takes place, a lot of subdivision of land that takes place, where lots are being in the process of being created, things are being in the process of happening to land, and in the midst of that, we can actually be having a transfer of interest with respect to land. Where a property developer gets involved and develops property, he wants to shift the interest in the lots that will emerge from this process as quickly as possible, because that brings the income back into the property developer to counterbalance the expenditure to actually do the work that he does, or she does, or it does. So, you've got to think of the larger context here of reality in terms of how land contracts and land transactions are taking place, and the conveyancing that's underpinning that. And of course, we're just really at the beginning of thinking about that process. One of the points that I tease out in the presentation for this topic is that in Queensland, we basically have a situation where the seller disclosure requirements are governed by, as I mentioned at the beginning, various areas. But what's emerged over time is that not only the contract of sale has requirements in that regard, but we have a plethora of legislation that's emerged imposing on the seller, and we tend to talk about seller and buyer in Queensland rather than vendor or purchaser, which is the nomenclature used in other places. A plethora of legislation dealing with a range of matters that is essentially about land planning and land control. Okay, so if you just scan through the notes or the chapter from the book, you will see, for example, reference to the Queensland Building Services Authority Act 1991, the Environmental Protection Act 1994. It's interesting, both of those pieces of legislation in the 90s. Okay, don't ignore that reality. Okay, when these initiatives, these legislative initiatives emerge, we'll see in a subsequent topic, that there is also it does use purchaser and vendor. That's quite true. Grant's just mentioned the other side does use purchaser and vendor. That's true. That is true. But I don't know why it's the discussion in Queensland tends to be couched more in the seller-purchaser language. I don't know. It's just that's as it is. But it's true. So this legislation is trying to direct and trying to govern and control what can be done with land in different situations and in different places. And if we think of just Queensland, all right, clearly there's differences between different. I know not both of you aren't sitting in Queensland. I know Grant's not sitting in Queensland, but differences just in terms of, and you can think about this in your own place, differences in terms of different areas. So just if I use Queensland, I was just up in the Gold Coast, for example, and the conference was at Bond University, and I was staying in one of those towers in Surfers Paradise, up about 26th floor or something, wonderful views over wherever, fantastic. But the point is that that great density and built-up environment in the Gold Coast, of course, it's not replicated everywhere around Queensland, right? There is a lot of development happening in Queensland in various ways. One of the very interesting things that I saw, and I think I was deliberately shown, actually, when I visited the Land Titles Office, was the Abbott Point development in North Queensland. And one of the things that staggered me was the rights that were granted to Palmer, who is behind the Abbott Point development, over the ocean by the Queensland government for the development of Abbott Point. And I really encourage you to go on and use the Queensland Globe hyperlink through Google Earth, which I've loaded onto actually the Land Law website. I don't know if I've loaded it onto this course website, but certainly on Land Law. And you can go in and you can search for Abbott Point or the descriptor, and then you get to see the rights over this great swathe of ocean in order to develop Abbott Point and to birth these enormous ships and so on and so forth. Very, very interesting. Okay, good. Well, we'll maybe show you how to do that with Google Earth and with Globe. I've put a presentation document onto the Land Law site from the Land Registry people, and I'm actually hoping to get them to come and join us in a Zoom session to walk us through things. I've actually tossed that out to them, and they said, yeah, that sounds interesting. We're happy to do that. So I'm hoping to do that a bit later in the term, so maybe that can facilitate a bit better understanding. But so you've got the Gold Coast there with the huge developments. The other thing that's happened in the Gold Coast, for example, just to focus on that area, as I was there recently, is you've had the tram, the light rail system, $1.2 billion light rail system, just become operational. And the day after I left, unfortunately. Great tragedy for me because I'm a great tram buff, but day after I left, it became operational. So this has had a huge impact on property owners and on businesses and whatever. Going forward, hopefully in a positive way, but during construction phase, significant issues. You've got huge developments in other parts of Queensland, and then if you go to far-flung Queensland, up into the northwest, Mount Isa, and Charleville and so forth, places like that, totally different proposition. You've got very large land holdings, for example, possibly under pastoral lease or under other types of holdings. And so, you know, this issue about development and how land is being used, and then the transactions that underpin the transfer of interests in land, you just need to have a holistic conception about that. Don't just think in a narrow way about land contracts and conveyancing being about the transfer of an interest in a residential purchase of a metropolitan dwelling sitting on a lot of land. That's just one example. There are huge and diverse possibilities here in terms of what we can be talking about. So it's important to remember that. The impact of these legislation, you know, variety of legislation, that's important in this area in terms of what can be done, and what are the restrictions and what are the obligations upon sellers with regard to making disclosures. And again, I refer back, as I did and as I have in the presentation, the Echo 360 presentation, to the Property Law Review document, the discussion paper 1. You will find at the end of that document a very nice table. Clearly, they've done a whole lot of work and they've got a lot of assistance helping them. A very nice comparative table with two aspects to it. One is it compares what the situation is in Queensland in terms of disclosure, seller disclosure requirements, and then compares that to other jurisdictions, all the other jurisdictions in Australia. Very interesting. Second, it looks at all of those sources of seller disclosure requirements in Queensland. So it looks at the requirements under the array of diverse legislation. Contract specifically spots the relevant clauses within the standard contract of sale and some general law. So that's I think a very useful snapshot for you, and a comprehensive explanation, which you and up to date, quite up to date. But just remember, it's only a discussion paper at this stage, so that it's at early stages. You know, there will be a final report, no doubt, issued by that project, making specific recommendations, potentially in the nature of maybe proposed legislative amendment and so on and so forth. But in the presentation, I do take you back and emphasise the key features of the reform initiative and what they're focusing on. So listen to that recording when it gets uploaded, because I think that's important. And I'll give you a heads up now that it will not pass by in terms of not, you know, I'll find some way to get you to think more seriously about it in terms of the assessments, because it's really the cutting edge stuff in terms of the reform that's impacting upon exactly and precisely what we're talking about. But we've got to get that balance between, you know, getting an appreciation of the current arrangements that is the law of the moment, but these reforms that are clearly coming, there's no doubt about that, and just working with that. As we had to in the last topic with regard to the property occupations legislation, which is still yet unproclaimed, we're still in this abeyance situation between the current framework and the proposed reforms. But we've got to sort of have an appreciation of both, really. That's the truth. All right. I'm happy to leave it there, people, if you are. Is that okay?
Sounds good.
Okay. All right.
Is there land law on Friday night?
Yes, it is. And I've sent out an email to people also asking whether there's any interest in a change of time on that. There's not much activity happening on land law from the student point of view. There's a lot of activity happening from my side, but on the student side, maybe the assessments aren't yet, and there's no required CP this time around. But things will heat up in that course. There's no doubt about that. I'm actually thinking of offering maybe a double not two topics, but a double 2 hours on our first class on Torrens on Friday, because it is so significant. But I'll send out a note about that. Yeah, so because it's fundamental to the whole structure basically, and also make a decision about when I offer the makeup class. I might do that maybe at the end of the recess. Just I'll think about that and get some responses from people. Yeah, we'll talk about that in that class. So, all right, I'll draw it to a close now for this class. And thanks for joining. And we'll see you next week at the revised time of 2 p.m. Okay, see you then.
Thanks, Michael.
Thank you.
Bye,
Good
Greg.
night.
Bye for now. Bye.